beg to mention item number 15, Your Lordship. Yes. The conducting counsel is not available, Your Lordship.
Who's the counsel?
Mr. SD. I'm praying for 2 weeks' time, Your Lordship.
Yes.
For the private respondent.
On pre-made by the petitioner. List this matter up to 2 weeks.
Item number 18, Your Lordship. Similar prayer. No objection, Lordship. Under the petitioner, Lordship.
18. You have for petitioner. You have for respondent.
Respondent JGDC.
1, 2, or 3, or 4. On pre-made by respondent 1, 2, and 3 respectively. The same not be objected to by the petitioner, but is adjourned. This is same up to 3 weeks.
And also item number 20, Your Lordship.
Petitioner, Your Lordship.
20 year for?
I'm respondent 1 to 4.
Objection, Your Lordship.
Respondent 1 to 4.
May it please Your Lordship, I beg to mention item number 8 to 14.
8 to 14.
These are also very old matters.
Old matter, Your Lordship.
Please ensure that it is being taken up.
Yes, Lordship.
8 to 14, Your Lordship.
On pre-made by the petitioner, not objected to by the state respondent and other respondents. That is adjourned. This is same after 2 weeks.
Okay.
Much obliged, Lordship.
Please, Your Lordship. I beg to mention item number 16.
Number?
16. Senior counsel is indisposed, Your Lordship.
On pre-made by the petitioner, not objected to by respondent. This is matter to 3 weeks.
I'll you pledge.
Supplementary cost list, item number 1.
May I, please, Your Lordship. This is anticipatory bail, my Lord, under 438, my Lord. My Lord, on 2010, my Lord, 2010 to 2023, my Lord, Shri Sultan Sarkar filed an FIR alleging that on 2010, his son Shri Shamim Imran Sarkar, while on his way to his relative's house at Kandargaon village, some 5 persons attacked him and flee from the spot, and his son was sustained injury, my Lord. Thereafter, the Rajabala police station, acting upon the FIR, registered a case, my Lord. Being case number Rajabala PS case number 14 in bracket 10 2023 under section 324, 307 and 34 IPC, my Lord, and accordingly initiated the investigation, and the petitioner is apprehending his arrest since the registration of the FIR, my Lord. Thereafter, the petitioner filed anticipatory bail before the Honorable District and Session Judge at Tura, and the same was rejected on 2011-2023, my lord. Thereafter, second anticipatory bail was moved before the same, and the same was rejected on 4/1/2023, my lord. Hence, this bail application before your lordship, my lord. My lord, the petitioner herein is a student of class 12, my lord, science stream. He's already filled his form for final examination, and his practical final exam will be commencing from 20th February, my lord. So since he is apprehending arrest, he is not able to concentrate on his study, my lord. Not able to, even on 20th February, his exam, my lord, final examination, higher secondary. So he is apprehending his arrest, my lord. So therefore, my lord, come before you. My lord, I have annexed the routine, my lord, at annexure 5, my lord. The Meghalaya Board of School Education, Tura, has issued the routine, my lord. At annexure 5.
Fine, we'll call for the case diary.
My lord, in the meantime, my lord, some protection may be, my lord. Since he's a student, 19-year student, my old year student, my lord.
What, Mr. Sam, learned counsel for the petitioner?
Under investigation.
And the victim has sustained minor injury, in the order.
The petitioner, okay. You said the father of the petitioner or the petitioner?
Well, petitioner himself, my lord.
Petitioner.
Yes, my lord. Shirazul
No,
Ali.
learned counsel for the petitioner was submitted that this application for grant of pre-arrest bail is referred on the ground that on the basis of an FIR filed on 21/10/2023, wherein Rajabala PS case number 1410 of 2023 under section 324/307/34 of IPC was registered, and for which the petitioner has been implicated in the said case, and police are now on the lookout for to arrest him. Accordingly, on such apprehension, this petition has been filed with prayer for grant of pre-arrest bail. Mr. H. Karmi, an additional PP, appearing for the state respondent, at the outset has submitted that before any final order is passed, the case diary of the said Rajabala PS case number 1410 of 2023 may be called for to enable this court to go through the process of, to go through the records indicating the process of investigation. Having heard the parties, this court at this point of time would agree that the case diary is required to be produced. Accordingly, the state respondent is directed to file the copy of the case diary when on the next date fixed. In the meantime, as prayed for, interim bail is hereby granted to the petitioner on condition that he shall not abscond and that he shall cooperate with the investigation as and when required. How long?
10 days, Lordship. 10 days. 10 days or 2 weeks.
List this matter on 8th February.
Hello, Pastor.
Item number 2.
My Lord, yesterday my friend Mr. Nobri informed me that he has some personal difficulties. So my friend may be here on his behalf.
What is this matter about, Mr.?
This matter relates to the order passed by District Council reinstating the Langrin chief.
Something connected with the inquiry
Connected,
report?
my Lord has passed the order.
Second inquiry has been conducted, has been initiated and is proceeding right now.
Going on. And this is the first one.
This is matter with
again
the first one.
First one. This matter is the first one.
In the
Couple
first
after 2
instance,
weeks,
we have
I think this is stray observation by this court that as far as the first inquiry is concerned, I think that has become practically redundant.
those observation is not there in my Lordship's
No.
judgment.
I said stray observation.
Oh, yes.
Yes.
So far as the second inquiry is going on, this relates to the first one. Since my friend is have difficulties, he come up after.
Respondent 4. On prey made by respondent 4. Matter is adjourned. This is after
after 2 weeks.
2 weeks.
Highly obliged.
Item number 2.
So I don't know, too, Lordship, the matter may be adjourned for 3 weeks' time, because the issue pending before the division bench is yes, if the court has
May
given
appeal is before the DB, Your Lordship. Come after 4 weeks, Your Lordship.
On prey made by the parties, this is matter to 4
After
weeks.
4 weeks. Apply.
Item number 3.
May it please Your Lordship. Lordship, the assisting counsel, Your Lordship, is on legs, Your Lordship. I pray if this matter may be taken up at the end of the board, Your Lordship.
What is it?
Your Lordship, yes, Your Lordship.
Lordship, as per the last order, the respondents are required to bring on record the compliance.
So, Your Lordship, we need some time, Your Lordship, this matter.
They have filed their affidavit now. They have filed their affidavit. Now, Your Lordship, may kindly produce the last order, Your Lordship.
What report is required to be filed?
Your Lordship, this matters,
The process, Lordship.
Your Lordship, this is
Process of compliance. Because as per the affidavit,
Okay.
this is a contempt petition,
Contempt petition.
Lordship.
so, Your Lordship, in this matters, we didn't went for the appeal in the division bench, and we have sent this one for the ministry for consideration. So now ministry is under consideration, and just I came to know just yesterday only, this ministry is going to file SLP. This is the intimation to me, because even then in the High Court also they can go for appeal, because the all causes come up out of the Supreme Court judgment. So in this angle, this court judgment is correct. So whether it can be filed or not, this is the matters is going on, and ministry is confident on these matters. So this is the intimation that I got.
But that is only in surface.
Until and unless there's a specific order by a higher court.
No, this really. So in the ministry it is still under consideration because ministry is having some observation in the matters, and I need some time, Your Lordship. And if it is not possible, then definitely it will be implemented. Because under process of implementation, it is not that it is not been taken. So already I have filed my affidavit on these matters. That's we have taken the matter with the ministry, and it is under because the only spanner has come up, Your Lordship, whatsoever intimation to me, because this court has passed the order based on the Supreme Court has passed the order and on the basis of it. So
it's a different issue. That's a
Lordship, may I submit? Lordship, in the affidavit, they are saying that they are taking up the process. Now, Mr. Devnath is saying verbally that they are taking a request to filing of any appeal before the Supreme Court. Lordship, these are
anyway, like I said,
submissions.
See, like I said, until and unless there is a specific order,
Lordship,
as far as these proceedings are concerned,
Lordship, in fact,
then we have to proceed. Anyway, I'll give you time to file the report, but do it.
Yes. Either way, it will be if they haven't gone for a further, then it's even if they made but not yet final decision has come up. So you see, it is
it's a bounden duty to comply with the court's order. Do it.
Yes.
As per my
This
instructions,
court has been liberal enough to give you time, but we cannot go on like this.
I'll bring on record.
Mr. Devnath Leonard CGC has submitted that the report as directed to be filed by this court by its order dated 6/12/2023 could not be filed today, and has accordingly sought for some time for the same to be filed. On prelim, the same is allowed. This is matter of 3 weeks.
Item number 4.
Please, Lordship. Lordship, in this matter, Lordship, I have not received the case diary. So, Lordship, I pray for some more time.
I'm on interim, Lordship.
You are on interim bail?
He is on interim bail.
What is required? Last order says case diary to be.
Case diary, Lordship.
Case diary. In this case, Lordship, already, Lordship, my name was implicated for having the reference of one vehicle, Lordship. And I disclosed in the crime branch that, Lordship, that because I already sold to one person, Lordship, and that very person, Lordship, now got the Jimma of that very vehicle, Lordship. There's nothing in this investigation, Lordship. By having the order dated, Lordship, 17/1/2024 for Chief Judicial Magistrate, Lordship, Nompo.
The IO would definitely note that, will record that in the case diary. You get the case diary and the latest status report?
Yes, Lordship.
Mr. Ishkarmi, Leonard Additional PP, has submitted that the case diary, as called for by this court, by its order dated 28/12/2023, could not be filed today, and has made a prayer that the same may be allowed to be filed, to be produced. Could not be produced, no? Be produced on the next date. As prayed for, this same is allowed. It is made clear that this said that the case diary should be produced on the next date fixed, along with the latest status report to be filed by the IO. As prayed for, in the meantime, the interim protection given to the petitioner will continue until further orders. This is matter after 3 weeks.
Highly obliged, Lordship.
Item number 5.
Hello, the respondents are yet to file affidavit, madam. Respondent number 1 is the collector.
You are for?
I'm for the petitioner, madam. And number 3 also not yet filed.
We require some more time, Lordship.
Who is for respondent 1?
That one is state respondents. Our instruction which we have received is a private dispute matter. The matter is pending before civil court between my friend who's represented respondent number 2 and 3 and the petitioner. We are yet to get for information whether we are supposed to.
You are a collector. You are a collector.
Well, I'm the collector.
She was, collector is the one who released the compensation during the pendency of the suit. So we plead.
But what is the role of the collector? Collector practically has no role except to to comply with the process.
My lord, the collector and others are parties in the pending suits, and despite of being a parties, he released the compensation. Definitely, he has a role to play.
Then you have to explain your.
He has to explain. He has to explain. And with regard to my lord,
2 and 3.
Phone number, Lordship, at that time 2 and 3, but now because 2 is the Dorbar of Langren Simship represented by my client, but now since my client has
acting chief will replace.
Now there's an acting chief which is represented by. Just the entire confusion.
Will issue notice.
So you are
suspension matter. With regard to this, new notice may be issued.
Lordship, I'll take instructions.
He may engage.
Because earlier you had appeared for.
Yes.
Because now there's a new person in office.
Ms. Arkundi Lanet GA appearing for the respondent number 1 has submitted that the counter affidavit could not be filed today and has prayed for some time for the same to be filed. On receipt of instructions in this regard. As far as respondent 2 and 3 are concerned, Mr. MNOPO Land Council has submitted that the counter affidavit could not be filed today and has also prayed for some time for the same to be filed. On preamble, the same is allowed. This is matter up to 3 weeks.
Yes. I do.
Item number 6.
May we please, Your Lordship? Your Lordship, our entering appearance today will be filing our Vaklanament cause of the day, Your Lordship. Lordship, I pray this matter may come up after 4 weeks' time.
Well, item number 6, 17 and 21. On the last occasion, the council has withdrawn Mr. Senior Counsel Custov Paul, Mr. Daryl Thapa were appearing in the Comora series matter. So Lordship has given an opportunity to engage a new counsel. So, my Lord, I believe my friend is entering appearance on behalf of them. Item number 6, 17 and 21.
So all same.
My Lord, they are different issue, but the same companies.
Same party.
Same companies.
Mr. Leonard Counsel has appeared today on behalf of the petitioner,
All the cases now.
but has however prayed that on being engaged as such, the power could not be filed today and has sought for some time for the same to be filed. Accordingly, on prayer made, matters adjourned for the day. This is here after 2 weeks.
My Lord, if similar order can be passed on all the 3 matters, my Lord.
Same order, Vituka.
6, 17 and 21. Item number.
Highly obliged, Your Lordship.
Item number 7.
My Lord, in this matter, the matter was substantially heard. In fact, the hearing was completed only, and we were given opportunity of filing a law, if there is any relevant law. Now, my friend has already submitted some decisions, but we, on that particular point on which it is relevant, on that exact, we have not yet found, but we are still looking. So today, my friend is also not there. So I would submit. I mean, Madam, is not there. So what I was submitting, my Lord, that by next day, if I cannot find anything, so whatever they have submitted, on that I also can rely. I also am in a position to rely on those. So some few more verbal submission opportunity will be given on the next day, and then the matter can be decided.
On pre-made by Mr. S. Chakraborty, Senior Counsel, appearing for the petitioner. Matter is adjourned. This is here after 2 weeks.
Right.
Item number 19.
notice, Your Lordship. Your Lordship, I pray that this matter comes after 2 weeks, Your Lordship. Let this matter come after 2 weeks, Your Lordship.
On pre-made by the petitioner, this is matter after 2 weeks.
Apply, Your Lordship.
Item number 22.
Yes.
Your Lordship, there is supposed to be a hearing for maintainability raised by the respondent.
Yes, so we'll hear.
Your Lordship, if this matter may be taken up at the end of the board, Your Lordship.
Now we are already at the end of the board.
Your Lordship, after DB, Your Lordship. Or if this matter may be taken up after 1 week, Your Lordship.
On pre-made by the respondent, list this matter up to 2 weeks.
Much obliged, Lordship.
May it please your lordship. Lordship, I seek indulgence, my lord. In item number 4, my lord, it was fixed for case diary. The case diary was received by me, and he was.
It was received by.
So I was
item number 4.
on legs on the other courtroom. Could not produce the case diary. Item number 4.
The council has already gone. Order has already been passed.
Then next day we'll produce it accordingly, my lord. But I just beg to inform that the case diary was received.
So, it's a request to all the council here. I don't know whether the court will convene immediately or soon after, but at 11 o'clock, I don't know if you have you've been put to notice that there will be 2 minutes silence. Wherever we are, we'll stand if we are in court or otherwise.
I cannot take it.
Daily costless, item number 1.
Oh, yes.
May I please, Your Honor? Here, Your Honor, the appellant was appointed as a...
We had gone to the records, and I feel my brother will not be able to take up this matter. Is this, oh, so we'll keep it on hold. There's nothing we can do. Since one of us, B versus Judge, could not take up this matter. Accordingly, the same is now to be placed before an appropriate bench. Kunung Tokong. We're out.
There is a delay, my lord, 90 days. We filed an application for condonation. They filed a reply to that also, my lord.
My lord, I am on the respondent, my lord. We have filed our objection, my lord, on the delay of 90 days.
90 days. 90 days.
90 days.
Yes, 90 days, my lord.
Why objection? See, more often than not, matters are, preferred to be heard on merits. But anyway, you have filed your objection. We'll take it up.
My lord, in para 4, my lord, of my application, I have stated, my lord.
Yes.
That after the judgment and order dated 20th April 23 was passed by the learned single judge in WPC number 180 of 2022, views and opinions were obtained from the concerned branch. After that, a decision was taken to prefer an appeal against the judgment and order dated 24/23. The council was instructed to draft the appeal and application for continuation of delay on 13/6/23. The drafts of the appeal and application for continuation of delay were received from the council on 18/7/23, and thereafter the same were finalized by the appellants and thereafter filed before this honorable court. In the process, a delay of 90 days has been caused. Basically, my lord, because as a government department, they have to take views and opinions from the higher branches and other branches, my lord. In the process of, and delay is not
But
much,
just-
my lord, it's
just
only
this,
90 days delay, my lord.
Dr. Morzika,
My lord.
you know very well that that is a very, oft-repeated excuse, and there are many observations made by even Supreme Court that relativism cannot be an excuse. Departmental, proceedings here and there, that cannot be, except if there are very, pertinent, reasons. Yeah. What is this matter about?
Well, here what happened, my lord, the respondent was serving Assam Rifles, my lord. And in Assam Rifle, on completion of 30 years, there is a provision for review of service, my lord. If he is deadwood or inefficient, my lord, after examining his service record and certain criteria, he is weeded out from service. So for that, a service review is carried out, my lord, on completion of 30 years or 55 years of age, my lord. So in the present case, my lord, he was found that in one of the years, that is 2019 and 20, he was not recommended for promotion. The rule is that in last 5 ACRs, he should be recommended for promotion in all 5 ACRs, my lord. And because he was not meeting the requirement of continuing in service, he was directed to be deboarded from service, my lord, on completion of 30 years of service. Against that, he came before this honorable court, my lord. This honorable court, my lord, there is an error apparent also, my lord, in this. The learned single judge, my lord, of course, I could have filed a review on that count. Learned single judge directed, because, my lord, learned single judge directed to communicate the ACR of 1920 to him, because it was not communicated to him. But further direction, my lord, if I may take your lordship to the impugn order, my lord. Para 7, my lord, your lordship, kindly see.
Para?
Para 7, my lord.
Just a moment. Where's the impugn order?
Page 177 also there. 177.
Yes.
It says, my lord, the learned single judge first directed us to communicate the ACR, my lord. If I may read from para 6, my lord, in fact.
Yes.
In view of the matter, this writ petition is disposed of with the following directions. The respondent authorities are directed to formally communicate the entries made in the ACR for the year 1920 to enable the petitioner to make a representation within a period of 1 month of receipt of this communication thereof. The representation so presented will thereafter be decided within a period of 2 months in accordance with law. Now, my lord, it is further directed that should the entries be upgraded in consideration of the representation, the respondent authorities shall constitute a review DPC for grant of consequential reliefs, if any, on the basis of the above. The entire exercise will be completed within a period of 6 months from the date of receipt of representation. My lord, there was a mistake, maybe in the course of hearing, my lord. The learned single just thought that it is a matter of promotion, my lord. In fact, it was not a matter of promotion. It was a matter of service review, my lord. There was no question, no, my lord, Departmental Promotion Committee in this. It was a service review matter, my lord.
That review will be an appropriate application for these. You can file a review application before the single bench for these.
For this, I could have.
If it is apparent,
my lord,
face of the record,
my lord.
Why appeal is not required.
My lord, that is one
It is
aspect.
something where, see, like determination of merit.
My lord.
Now, if you say that, and it was not a case for promotion.
My lord,
then that
yes,
is
my lord. On this aspect,
on the face of the record.
I agree, my lord. This was a case of review, my lord. My lord, the second aspect, why we have come on appeal, my lord. My lord, here, my lord, Assam Rifle is headquartered in Shillong, my lord. So it is subject to the jurisdiction of this honorable court as well as 4 or 5 other high courts, my lord, because it is operating in the entire northeast. Now, in the same issue, my lord, Guwahati High Court is passing a different kind of order, my lord. I've annexed the orders, my lord. And even Supreme Court, but this honorable court, my lord, the then Chief Justice, my lord, in one of the matters passed an order. Of course, we have not filed an SLP against that, my lord. But there are even subsequent reasons after that also, that in service review on completion of 30 years, communication of ACR is not required.
In what would be the basis? Because the incumbent should be put to notice as to why his service should not be continued. But based on certain factors.
But your lordship is in the bench in that matter, my lord.
I have forgotten.
I'll place that judgment, my lord. But today, if the delay is condoned, my lord, on the next date, I'll argue on the matter.
Mr. Kumar, I think we'll condone the delay.
My lord.
You said, see, the submission of the petitioner there. It's submission with regard to promotion only. How can you say that single judge is committed an error there? See paragraph 3 of the judgment.
My lord, para 1, if lordship kindly sees, my lord.
Come to para 3.
My lord.
That is submission part. Submission part. Para 3. The grievance was only with regard to that.
But the fact remains, my lord, this is not a case of promotion, my lord. Para 1, if lordship kindly sees, my lord. Para 1 on the same judgment, my lord.
Yes.
It says, my lord, the petitioner who was serving as Havaldar being aggrieved with the impugn order dated so and so, whereby he has been directed to retire from service, my lord.
Yes.
That is all right, but if you go proceed further,
My lord.
see, you get an impression that basically he is not aggrieved by the direction to take. Only thing is that he wanted that is promotion. He should have been accorded promotion before he is made to retire. That is what this single bench.
Yes, yes.
That is what. So I don't think what you are
No.
saying is correct. Probably.
Parawan is very clear. Yeah, you read the next line. It says he was directed to retire for promotion.
Yes. Whatever the averment in the writ petition, but then it is apparent that at the stage of hearing, the submission was made limited to promotion only, nothing else.
No, my lord. I'll just clarify that aspect, my lord. My lord, the promotion is a little bit interconnected with that, my lord. My lord, if kindly comes to...
That was the main subject in this scene. Final hearing judgment is all about this. It has nothing to do with his retirement. Even if you find that he was eligible for promotion, that will be only for regard to this thing for calculation of service benefits and all. Nothing else.
No, my lord. Lord, sir, kindly comes to page 114, my lord. For a moment, my lord. (114).
Yes.
My lord, this is my lord. These are the instructions, my lord. That service review Assam Rifle, JCOs, the junior committee.
We are not on this. Here, as far as a single bench judgment, it's concerning promotion only. Nothing.
My lord, but the issue before the learned single judge was not promotion, my lord.
But the submission was that only on the basis of that only. And it is this entire thing centered around non-communication of SCR.
My lord, communication of SCR is
Your
required.
submission also, you see, it's there that you have admitted that SCR for relevant was not been formally communicated. So this decision was centered around that only. See, paragraph 4.
My lord, if I may take to the prayer of the writ petition, my lord.
It can be molded. Why not? You cannot make a confined to writ court. You see, it may happen like this. When a case is filed, prayer was made. But then maybe at the final hearing.
My lord, the promotion was not an issue at all, my lord, in this matter. That is why I am trying to submit, my lord.
Anyway, we'll hear the matter.
Well.
So, Mr. Kumar, no strong objection.
My lord. My lord again.
Dr. Musica at DSGI, who has submitted that an appeal was preferred by the applicant. Oh, there are by the applicants herein against an order, judgment on order dated 20/4/2023, passed by the learned single judge of this court in WPC number 180 of 2022. However, in the course of preferring the appeal, a delay of about 90 days has been caused. The reason being that specific instructions as well as interdepartmental procedures and proceedings could not be completed in time to enable the appeal to be filed before this court. On this ground, therefore, the prayer is made for condonation of delay in filing the related appeal. Mr. B. Kumar, Learned Counsel for the respondent, though has submitted that though the respondent has filed an objection to the petition for condonation of delay, however, at the hearing has candidly submitted that no strong objection is made if the delay is condoned. Accordingly, on this court having considered the submission made and on consideration of the submission made is of the opinion that the delay in filing the appeal is to be condoned. Accordingly, the delay of filing the appeal of about 90 days is hereby condoned. Petition disposed of. The appeal is hereby admitted on board. Ministry is directed to give appropriate number to the same. This the appeal for hearing after 2 weeks or 3 weeks? 2 weeks.
3 weeks, my lord.
3 weeks.
My lord. Highly obliged, lordship.
Item number 3.